Here's Michael Smerconish.
There is an editorial from the Wall Street Journal posted in my website today under the headline, How to Get Away with Manslaughter. How to Get Away with Manslaughter. When I read it, I immediately thought of my next guest, who is the nation's foremost authority on the subject we're about to get into. But here's a taste from the Wall Street Journal. It says, Shaynna Sims was haunted by the fact that her husband had been having an affair. So when his lover died in 2015, Ms. Sims went to a viewing at the Tulsa, Oklahoma funeral home. There, she mutilated the woman's body, which prosecutors later said had both breasts crudely cut off. She also took graphic pictures, including one with her wedding ring prominently displayed. Ms. Sims received 16 years in prison in 2017, but last month she was freed. Add this to the toll from the Supreme Court's 2020 decision in McGirt versus Oklahoma. In that same case, Justice Neil Gorsuch, joined by the court's liberals, held that Congress never formally dissolved the Creek Nation's historical reservation. The same logic has been extended to 5 other tribes. As a result, the state's authority to prosecute crimes involving Native American perpetrators and victims has vanished in nearly half of Oklahoma. The woman whose body was carved up, she was 1/64th Creek, an amount consistent with having one Native American great-great-great-great-grandparent. And it goes on and on and on. This brings me to my guest, who's been here before and is just terrific in terms of his knowledge of the subject matter. ASU law professor Robert Miller is the Willard H. Pedrick Distinguished Research Scholar at ASU, faculty director of the Rosette American Indian Economic Development Program at ASU as well, and the author of several books, most notably the one that I have read, Native America, Discovered and Conquered, Thomas Jefferson, Lewis and Clark, and Manifest Destiny. Professor Miller, thank you so much for coming back to the program.
Thank you for having me, Michael.
So that alarming Wall Street Journal editorial, I mean, it presents a lot of facts and all the citations to the Supreme Court. People will read it and wonder, well, what's going on here? What is it that they should know?
Well, the first thing I think of, Michael, is that this is legal analysis by hysteria. This is legal analysis by hyperbole. Any change in jurisdiction, any change in the power of a government to prosecute you or me, of course, is going to result in some anomalies. And what we have going on in Oklahoma, as you said, in reaction to Justice Gorsuch's opinion in July of 2020, is that Oklahoma found out that it has illegally been exercising criminal jurisdiction and civil jurisdiction over Indian nations and Indian peoples in Oklahoma for over 100 years. The real analogy that's applicable here would be like if a crime occurred in Texas and Oklahoma was so mad about it that it wanted to prosecute the people. Well, that is, in law, we call that ultra vires. It means beyond the power of that Oklahoma government to get involved in that crime in Texas. And so the McGirt decision from July of 2020 set out the parameters under federal law and under the federal constitution of Oklahoma's powers over various crimes that might happen in Oklahoma. But because they happen in Indian country, on Indian reservations, only the federal government and only the tribal governments have criminal jurisdiction.
So what then is the law of the land in those Indian areas of Oklahoma?
Congress defines, in 1948, Congress enacted a statute called Indian country. It defines what is Indian country. So that's a legal term of art. The Congress took cases that the Supreme Court had decided for probably 50 some years and drafted a statute. And Indian lands in Oklahoma are Indian country. Previously, we assumed it was under this federal statute, which is 18 USC, United States Code 1151, which had 3 separate provisions. Previously, everyone thought the only Indian country in Oklahoma was under 1151C. But what McGirt decided, as you said in the opening, was that Congress had never terminated the dozens of Indian reservations that are in Oklahoma. So they all constitute Indian country under that federal statute, but under subdivision A, under 1151A. And as you said, later courts, these are state courts now that are applying McGirt, and they have found at least five, they have re-recognized at least five other reservations in Oklahoma. My own tribe's reservation from 1888 will probably be re-recognized in the next few months. So yes, there's quite a change going on in Oklahoma. And as I said at the start, any adjustment in jurisdictional boundaries leads to situations like the editorial is dramatizing.
Well, they're pretty dramatic stories. Richard Ray Roth driving a Chevy Tahoe through Wagoneer in 2013 hits a 12-year-old Cherokee boy with a bicycle, didn't immediately call 911. While the boy lay dying, he drove home, got his wife, returned to the scene, claimed they'd had only 2 beers, yet his blood alcohol level was nearly 4 times the legal limit. Guilty verdict on charges of manslaughter, gives him 20 years, then overturned in September. So what is the judicial system right now handling these cases in the vacuum that I think you've described?
Yes, these are very dramatic, very serious, and very human problems and issues. I want to make it very clear that the fault lies at the feet of Oklahoma, who for over 100 years has exercised jurisdiction in the law, that's power, folks, over people that it had no right to do. The United States Supreme Court even told Oklahoma in 1926 that it was the federal government that had the power to prosecute several of the crimes that you just mentioned and the examples that the editorial is using. So I want everyone to realize that the state is at fault here. The state knew it was at fault, but has tried to exercise criminal and civil jurisdiction because it wanted taxation powers and regulation powers over Indians and individuals. So,
Professor, I have to believe that people are listening to us, some people across country right now in their cars or wherever they might be, and they're scratching their heads and they're saying, wait a minute, I don't understand. You're telling me that in a vast portion of Oklahoma, designated Indian lands, American jurisprudence as we know it doesn't apply?
Oh, it's American jurisprudence. But what has complicated the situation, Michael, is it is now Indian country. And so federal Indian law, federal law, the supremacy clause of our Constitution applies, and state law does not apply.
Okay, and who administers that? Are there Indian law judges?
Oh, yes. All of these governments, all of these tribal reservations that have been re-recognized have tribal courts. They exercise criminal jurisdiction. They coordinate with the federal government to prosecute people. And it's very important to note that most of these tribes already have all sorts of agreements with the state of Oklahoma on every issue you can imagine, Michael, to work out these intergovernmental relationships. So Oklahoma, for 3 or 4 or 5 decades, has been dealing with tribal governments on many of these issues. Almost every one of these tribal nations that we're talking about, Michael, their police officers are cross-deputized with county and state officers. State, county, and city officers are cross-deputized with tribal governments. So hopefully no one will fall through the cracks and none of these dramatic examples, and yes, human interest and very serious issues. We wish they weren't happening. But again, I want every listener to realize that this is Oklahoma's fault.
Because from the journal editorial perspective, these are folks protecting their own.
I don't understand what you mean.
Well, to read the editorial is to come away thinking that the administration, I'm trying to word this carefully so that I don't get caught up in the semantics, but that if crime is committed in Indian country, then Native Americans are protecting their own through the judicial system.
If I'm understanding you correctly, I object to that statement. Tribal governments are just as interested in law and order as is anyone. And the federal government exercises a lot of criminal jurisdiction in Indian country. So you now have 2 governments that have possible criminal jurisdiction over Indian individuals who commit a crime in Indian country. And I want to make one point to you. This editorial, as is everyone, thinks thousands and thousands of criminals are getting out of Oklahoma prisons. In the Supreme Court arguments back in 2019, Oklahoma said thousands of criminals would get out of jail. And I want to give you some statistics that were published in the Voice of America newspaper in July. And these statistics were taken from the Oklahoma Department of Corrections. The Oklahoma Department of Corrections reported just 4 months ago that only 127 prisoners had been let out of Oklahoma prisons, and 57 of them had been released to the street. That's how the Department of Corrections worded it. So if my math's correct, that means more than 70 of them were immediately arrested by the federal government and or the tribal government and are currently in jail and or being prosecuted by the federal or the tribal governments. So only a few people are getting out of Oklahoma prison and not being immediately seized by another government.
Professor, the McGirt case, the McGirt versus Oklahoma case, did that break, as usually has been the case, along ideological lines in the Supreme Court of the United States? I'm trying to understand what's the conservative or progressive position on this issue.
You made an interesting point at the start. Justice Neil Gorsuch, who was President Trump's first appointee, he's an originalist and a textualist, which if your audience knows what that means, that is the conservative wing of the court. This is a political theory of interpretation that Justice Scalia is most famous for. Just read the original document, just the Constitution or a statute that Congress passes, and enforce it the way those founding fathers of the Constitution or the drafters of a federal law intended it. So Gorsuch took the law and asked the important question, did Congress ever disestablish Indian reservations in Oklahoma? He searched the law. He found no evidence that Congress ever got rid of Indian reservations in Indian country. Oklahoma admitted when it became a state that it would never exercise jurisdiction over tribes, tribal peoples, or their property or their rights. And that's why I have said twice that it's Oklahoma that for over 100 years has violated the law. Now, back to your question. I have written 2 articles on McGirt. I just finished a book we submitted to the publisher. And it's the other conservatives on the court should have joined Gorsuch's opinion because they are all for avowed textualists and originalists. They should be looking only at what Congress did to these Indian reservations.
Well, how did it break? What was, if you remember offhand, what was the lineup in McGirt?
Justice Gorsuch joined the 4 liberals, as you said at your opening. And so the other 4, Alito, Thomas, Kavanaugh, and Roberts, all dissented quite vehemently.
Hey, when your book comes out, let's come back and redo this conversation. In the meantime, just sum up, what does ASU law professor Robert Miller most want people to know about this controversy?
This is really not that unusual in the United States. I teach in Arizona. 27% of this state is Indian country, Michael. This state and the tribal nations cooperate together. They sign compacts. We call them agreements to share jurisdiction, share taxation power. It's why I emphasize that Oklahoma's already been doing this with the 39 tribal nations that are inside the state of Oklahoma. And this is what needs to happen. Stop going to the Supreme Court. Stop writing editorials that are all about hysteria and work out what governments do all the time. Cooperate, protect the public, provide governmental services. Justice Gorsuch said this is what should happen afterwards. And let me tell you what his conclusion was. If terrible things happen, Congress has the power to fix McGirt v. Oklahoma. So that's where we're at, Michael. Let the tribal nations, let the federal government of Oklahoma work these issues out. And if it becomes some just terrible problem, let's look to Congress to fix it.
You have brought your A game again, and I am appreciative. Thank you so much for that tutorial.
Thank you for having me on the show.